We're going to focus, after having looked earlier this morning at access to courts and yesterday at emergencies specifically, and also the rights of people with disabilities, on two particular human rights that have also been quite directly affected by the COVID-19 pandemic. And those are the freedom of expression and the freedom of assembly, which I will focus on for this morning. And you can see here on the photo an attempt by people who had seen enough of their interior of their house to go outside and to protest, and they did so sitting on a square, taking into account physical distancing, each of them at a perfect 1.5 meters distance from each other. I think this is how some authorities would love to see it if they still allow for demonstrations. And so this is an example of a very orderly protest, but of course it's not always going that way. And we have seen that in many of our countries in the Council of Europe. Here is an example from my own country, the Netherlands, this summer, when a large group of people demonstrated in our government city, The Hague, against the anti-COVID-19 measures by the government, which they saw as encroaching and limiting their freedom. So this is a regular protest, although part of the protest went berserk, out of hand, wrong, and led to some small skirmishes with the police. And then this week in the Netherlands, we have, since last weekend, a curfew, and this led to much more vehement protests, which eventually turned into riots in a lot of different cities in the Netherlands, where it is difficult to distinguish whether that was originally a protest or whether that was from the very start rioting and taking just the cue of an evening curfew as a reason to go into the streets. And this led to attacks on railway stations, shops, government buildings, and lots of clashes with the police in the last few days here. And this immediately shows the difficulty with demonstrations and public assemblies, that maybe some of the participants have peaceful notions and really protest against a certain government measure around the pandemic, and others are just out there to riot. And how do you distinguish, and how do authorities deal with that? And we've seen these clashes in quite a number of our countries, I think. So that is one of the issues we will deal with today. First, looking at the freedom of expression and specifically also access to information, and a bit later to freedom of assembly. And for reasons of time, I will not go into freedom of association. So I would love to start with a question which also refers a little bit back to what you've discussed yesterday, and it's a very simple one. These two rights, so Article 10 and 11, freedom of expression, can they be derogated in times of emergencies under the European Convention on Human Rights? Please answer a yes or a no. So can freedom of assembly and freedom of expression be derogated from in times of emergency, yes or no? Can you all vote right now? I hope if most of you have voted. See the results as well of the vote. Yes, most of you correctly have answered that indeed these rights can be derogated from during emergencies. Although, as you've also heard yesterday, derogation doesn't mean that they cannot be limited at all. So how is this, legally speaking, linked to emergencies? So Article 15 of the European Convention that you discussed extensively yesterday does not mention Articles 10 and 11, so freedom of expression, association, and assembly. It doesn't mention them as non-derogable rights. You've seen yesterday that non-derogable rights, for example, the prohibition of torture and several other rights. So by inference from that, these rights, Article 10 and 11, can be derogated from. So these are exactly some of the rights that have been used here to not be fully protected in times of emergencies. What you also probably discussed yesterday, I would guess, is that only a relatively small number of the 47 state parties to the European Convention have really formally derogated from the Convention last year, and usually just for a few months. So most states apparently have chosen to use the normal legal framework of the ECHR to deal with the COVID-19 pandemic and have not found it necessary to formally declare an emergency at the European level and notified at the European level. So this also means that just for that small group of states, more restrictions than in normal times are possible, and only for as long as this formal emergency lasted in those countries. So to conclude very simply, for most member states, for most state parties to the ECHR, the normal system of restrictions to the rights to freedom of assembly, association, and expression apply. But of course, these rights are heavily influenced by the very factual situation of the pandemic. So the measures and the policies that governments have set in place to combat COVID-19 have very directly affected these two rights. Obviously, because of curfews, lockdowns, etc., very often public protests in large groups have become quite impossible, be it for the very simple fact that many countries have put in place maximum numbers of people who can be outside at the same time in a group. And some countries have even instaured full bans. And the same goes for freedom of expression. Several countries have really used the time of the pandemic to create stricter laws or to more strictly enforce existing laws, whether they relate to fake news in the context of reporting about the pandemic, or whether they are about any other opinion being voiced about the situation of the pandemic, including other things than government measures. So, for example, hate speech, to which we will also turn today. So obviously the pandemic has influenced, has affected these two rights. But you could also say in turn, these two rights are extremely important, especially during an emergency, especially during a pandemic. Why? Because they really are some of the foundations of democracy. If a government makes a policy which combats a pandemic, then it's important for the governments in democratic society to know what their citizens think about this, and that they hear those opinions, that media are still free, and that people can discuss these things, and therefore that the voices of the people can be heard. And just like earlier this morning, you heard about the courtrooms and the restrictions to that, at least in the first few months of the pandemic, here also these voices of people have been less heard because the demonstrations were more difficult or prohibited, because fake news laws have been used to sometimes very much restrict or even suppress views on the pandemic and on the policies of states around the pandemic. So there's a mutual feedback loop here, you could say, between the two different things, the rights on paper and the practical situation of combating COVID-19. So if we return to the law itself, the normal, as I said, in most states, system of assessing whether a state went too far or acted in line with the European Convention or not applies. So always the question to be asked, if a state takes a measure that affects freedom of assembly or association or expression, would be, does the situation fall within the scope of one of those rights? So if there is a lockdown which prohibits people from being outside at certain hours, that affects their right to protest because they can only do so at certain hours maybe, or they cannot do it in big groups. So this would always be the first thing to check. And then the second thing is, was there actually an interference with a particular right of a particular person or group of people? And this is very familiar, I think, to all of you. If there was an interference, if there is a new law or a new policy in practice that restricts people in the enjoyment of their rights, then the European court, but also domestic courts, would need to check, was there a legal basis, was there a legitimate aim, and was it really necessary in a democratic society? And all these really relate to the COVID-19 situation. We could assess them here. First of all, on the legal basis, very often countries have not immediately been able to create laws, be it for the reason that some parliaments even functioning for several weeks, but they have created ad hoc measures, sometimes based on temporary executive orders by the government or by local governments. And the question here would always be, are those types of measures, could they be seen as really having a legal basis? Are they sufficient under the European Convention of Human Rights? Several countries have taken a few months to create laws, and the meantime is a bit of a gray zone, a limbo, you could say. And for the second element, did state authorities have a legitimate aim to take a certain measure? That might be an easier one to answer, because both in Article 10 on freedom of expression and Article 11 on freedom of assembly and association, one of the permitted grounds to restrict human rights is public health, which has not been very often invoked before last year in the history of the European Convention, but now is, of course, extremely relevant. As a teacher, I always used to joke with my students for the last 10 years, imagine a situation where there would be a dangerous disease and then public health would be a legitimate aim for governments to take certain measures. And now we are all in that situation, so it has become a reality. So that's one possible legitimate aim. The other is the more broader, the rights of others, the rights of other people. So you might restrict a protest because that would spread the disease and therefore endanger other people. And the third element, the necessity in a democratic society, is very often the crucial question, assessing whether an ECR right has been violated. And in the context of this pandemic emergency, it's a very tough one for reasons that you can well imagine. The first tough question under this element of necessity or necessary in a democratic society is what I would call the what if problem. Governments have to decide as the pandemic has unfolded what is wisdom, what they should do. They do not have full knowledge. Some prime ministers said in Europe, we only have half of the knowledge, but we have to take 100% of the decisions. And they simply cannot entirely know what would happen if they would wait a few more weeks with a restrictive measure, or whether they are overreacting. So this is a very big difficulty to set in place new policies. A second problem quite related to that is that we have rarely seen that governments have had to rely so heavily and so directly on non-politicians, and that is your own experts, more specifically medical experts, to base their decisions on. In some countries, there's been criticism that the governments have done too much of technocratic decision-making based purely on medical reasons, epidemiologists, etc. But of course, in the end, it is still a political decision, but these politicians are not trained in these particular fields. And of course, then there are broader concerns. Why would we only have to look at medical interests? Why not also at societal effects of the measures? And do you need other types of expertise for that? And a third problem is what is usually seen under this necessary and democratic society test is there really a pressing social need to take a certain measure to restrict a certain human right? Well, this pressing social need is also less clear here because it could work both ways. Sometimes in some countries in the last year, it could be seen there as a pressing social need to make measures more strict. In some countries, governments reacted very late and people were calling for strict, faster measures to stop the spreading of the pandemic. So that would be could be seen as a pressing social need. But it can also work the other way around. In countries where strict lockdowns have been set in place, many people have been arguing for some relaxation of the rules because it negatively affected, for example, social well-being or the possibilities for children to get education in a safe environment at schools instead of at home. So there, the pressing social need could point the exact other way. So those are a number of the difficulties if you use the normal scheme of assessing whether a human right has been violated in this particular time of a pandemic. And the same goes for the other type of measures, which are not restricting human rights to people, but where it's the other way around, where you actually require from the state to take action, so the positive obligation. That may also be at stake. And there the normal general test is, has a fair balance been struck between the interests that the state tries to protect and the interest that is countervailing? So here, for example, there could be positive obligations under human rights law, under the right to health, versus, or even the right to life, to act for the government, versus the right to privacy or the right to freedom of assembly. So rights can clash. And here the test would always be whether a fair balance has been struck by the authorities, which is, again, very difficult to do in the midst of a pandemic. Maybe in hindsight, in 5 years from now, it's easier to see that. But how tough can we be on governments here in saying that they made a wrong balance, a wrong choice, because we're all in the middle of this storm on the ocean. And of course, the difficulty is even more present because some of those interests or rights are not even in the ECHR. For example, the right to health as such is not, although it could be inferred partially from the right to privacy, for example. So lots of difficulties, even in the states that haven't formally declared a state of emergency, lots of legal difficulties of assessing all the measures under the ECHR. So let's move to some of the specific issues here. The first is access to information. Not just the government needs information, but the general public too. This affects all of us. These measures and restrictions affect all of us. So it's all the more important to know how the governments are deciding, on what basis they decide what kind of information they base themselves on. But many countries have, especially in the first months of the pandemic, restricted the access to government information because they simply felt so overwhelmed, or maybe because it came in handy because they didn't want to share it anyways, or they found it too politically sensitive. And again, an example from the Netherlands, in April, so a month after the pandemic arrived in my country here, the government officially announced it would put all requests for access to information on hold until the 1st of June. So for more than 2.5 months, the government said, we will not give responses to access to information requests from people or journalists. Now that is extremely restrictive, of course, especially if people really yearn for information. So how is that to be seen from a human rights perspective? Well, it's first of all important to realize that Article 10, which people usually just call the freedom of expression, also includes the right to access to information. But this is not an unlimited right. It's not a right without any limitations. So how can we then legally see to what extent there is a right to access to information, of state-held information? So if there's someone in society that wants to know some information related to the pandemic and wants to get it from the government, do you have a right to that? Well, it's been decided already several years ago in a different context by the court in the case of Magyar Helsinki Bizottság, which is the Hungarian Helsinki Committee against Hungary, a Grand Chamber judgment of 2016, that there are several factors which should be taken into account to address whether really a government can refuse or not an access to information request. 4 contextual factors, basically. The first is the purpose of the information request. So is the purpose that it becomes part of a media's work to inform people, or is it some contribution to public debate? Is that the purpose of why certain information is asked? Or is it something else? Is it just someone who wants to know genealogical information where their grandparents came from? Something completely different, purely private. Secondly, the nature of the information sought. The type of topic that the information is about. Is that something of public interest or not? That also matters. If it is of public interest, there's a greater chance the state has an obligation to provide it. Thirdly, what kind of applicants are we talking about who ask for information? A media organization or a civil society organization, an NGO? Is it an academic researcher? These are categories that have been recognized by the court to have a certain position, a certain interest in getting information. And fourthly, is the information actually available by the government? Do you want something that the government already has, or are you requesting the government should actually start to collect certain information? I'll give you an example. The government has statistics on crime, but maybe you want them to collect statistics on the gender identity of criminals or their economic and social position, and maybe not all that information is available for the government itself. So are you asking them to actually start collecting it, which would go further? So these are 4 factors to be taken into account. And if we take them into the context of the pandemic, looking at the first one, the purpose of the information request. So is it important to have that information in order to report on the pandemic itself or on the anti-COVID-19 measures of the government? If it's about that, there's a bigger chance that the government should open up about it. Secondly, the nature of the information that is sought. Well, this type of information is clearly of public interest. It is not a private type of information that just someone wants out of curiosity. This is important for everyone in society currently. Thirdly, by whom is it asked? Well, very often these requests for information in the past year in almost all countries have been done by the media themselves. That again points towards more chances of having access to that kind of information. And fourthly, is that information already available or should it still be collected? Well, it depends. Again, here in the context of COVID, some information is held by the government, others is not known. Some countries have very much decentralized, for example, testing of COVID, so they don't have easy national numbers. And the same goes for the vaccinations. Others have all that centrally located information. So that would depend. So just to again show you that the general normal system of assessing this particular right could be easily applied to COVID, but the answers, the application is not that easy. So it all depends on the particular context. Who is asking for it? For what purpose? Is that information there already or doesn't need to be collected? And then I'm not even talking about countervailing interests, contrary interests, such as maybe some privacy interests. So that is one element that is at stake. And there's already a quite long question. If you allow me, Jurai, I come back to that at the end. A second element of Article 10 is the freedom of expression itself. So how does that relate to the COVID-19 pandemic? Well, we are all aware of the big discussion around accusations and sometimes real existing fake news, which was an older discussion in politics already, but has become all the more prominent in the past year. And here you see some examples of myth around COVID-19, ranging from very mundane issues that in some countries there were rumors about there's a shortage of toilet paper, so we have to quickly buy it all, or in other countries it was said that the virus will die if the temperature is above 27 degrees Celsius, or if you go sunbathing, you will get rid of the virus. Well, unfortunately, all of that is untrue. And especially because this so directly relates to people's private lives and health conditions, you can imagine a big interest in securing valid information and to avoid the spreading of rumors which might be dangerous. So how does that evolve in practice? There's already one application pending at the European Court of Human Rights specifically about this issue of potential fake news or not during the pandemic. And that's a communicated case from last year. We'll probably have to wait several years before we know the court's judgment. But we already know that the court has communicated the case to the country at stake, Russia. And this, in a nutshell, is about this particular Instagram post, which was this text by a lady in a small city in Russia, which was the following. She claimed there has not been a single case of coronavirus infection in the Krasnodar region. No patient who tested positive has received a document showing a confirmed virus infection. Think why the authorities would need it. No one will talk about it for fear of being fired or killed. Money is being offered for agreeing to list the coronavirus as a cause of death in the death certificate. Everyone knows it. So here she was claiming, not very coherently, but apparently that first there were no casualties of real corona in her region, and also that there was a possible corruption in how the authorities dealt with it, in what type of death cause they put on death certificates, and that you could buy almost a certain affirmation of a death cause. So she was charged locally with disseminating untrue information on the internet because she did so online, and she was required by a local court to prove her statement. Now, this is an example clearly of freedom of expression, which directly relates to fake news, directly related to the pandemic itself. Now, although we, of course, do not know yet the answer of how the court will decide on this issue, is it too far going to convict someone for saying this, for putting this online, or is this just an opinion, or is this dangerous kind of fake news from a private person? Well, again, we do have some clues from existing case law. The first is that we know that media and NGOs have a responsibility to provide reliable and accurate information in general when they act as a watchdog of the government. Again, from the same case that I mentioned earlier. And secondly, we also know that media organizations and NGOs could be held responsible for publishing false information when they are not, when they haven't checked the veracity of the information. So if they're not even doing any trouble to check if what they're claiming is true, they could be held to account for that. So these are some general rules. And then we had one first fake news case at the European Court 1.5 years ago, which was from Poland, Brzezinski case, in which an opposition politician in a local election made a little book himself where he criticized the local mayor for mismanagement and a town councillor for corruption. And this was combated, and he was convicted for that. And that was a big discussion about whether this was actually true or a lie, whether it was an allegation that was fake or whether it was real. And in that case, the court indicated some, again, considerations that you should weigh as a judge when you look at this type of fake news cases. The first is the quality of the public debate. In that context, it was an election time, must be combated, must be protected, and false information spreading must be combated. So in a political context, it's important to combat spreading false information. Now, to what extent discussions about COVID are political, a debate is possible, but we could, by an analogy, see that it could apply. Well, secondly, it talked about free flow of information, important in election time. Well, we could say in a pandemic, also this free flow of information about the pandemic is quite important. Thirdly, national courts should assess this in the view of the European Court, but in this case, the national courts did not check whether the allegations that this politician made had a sufficiently credible factual basis, and they just said these are lies without really checking. And also, a person cannot be required to prove the truth of the criticism they make. So not all responsibility is on the person making the expression. Although the more professional the institution that makes the expression is, like media, like NGOs, the more responsibilities apply, and maybe a bit less in case of private persons, and also some provocation and even exaggeration is allowed. So these are some factors to take into account, which we could also use for COVID. And then more generally on freedom of expression, on the content of it, two important things to note. One is that if you discuss health issues, this is seen by the court as an issue of general interest and therefore has a high level of protection for this kind of speech about health. And secondly, the same goes for discussing political issues, and policies of a government about COVID-19 are a political issue. And there, a whole lot of things apply. There's a high protection for if politicians criticize the government on measures, so COVID-19. State institutions such as the government should be able to take more criticism than other people. There's a high protection for political debate in general, but the government could act against intolerant expressions and against hatred. Criminal sanctions generally cannot be imposed in the shape of an imprisonment, only by rare exception, only if it's really inciting hatred or violence, and then only when it's proportionate. So these are some general things that we again could use for COVID-19. And then finally, specifically on hate speech and corona, some groups have been attacked by politicians or by private people on having a certain kind of ethnicity. For example, the famous one is the China virus. You know, the former American president accused the virus of being that, and people from Asia were for a long time accused in the first few months of the pandemic of being dangerous to others. So hate speech in general should be combated, and you're going to just show you one specific thing, and that is, of course, shocking, offending, or disturbing speech is allowed, but there should also be tolerance and respect for the equal dignity of people. So if a private citizen would say this is all the fault of Chinese people in Europe, then that could be combated by authorities as hate speech. Although hate speech laws themselves should not be abused to suppress certain opinions. So if there's a real political debate, societal debate going on, hate speech should not be used as a disguise to just suppress opinions. And then, because time is running, I'm going to quickly go to a second question for you. That is a simple multiple choice question for the other final topic of my talk, and that is the freedom of assembly. So in your view, and this without knowing maybe too much about it, the freedom of assembly under the European Convention, does it cover A, gatherings in public places, B, gatherings in public and also in private buildings and houses, C, gatherings online, or D, all of those things? Please type your answers. Great, it wasn't that easy. Half of you said all of the above, which is indeed the correct answer. So it could even be gatherings in our own home. That is also protected by freedom of assembly, and also gatherings online. So all of those things are indeed protected. And we've seen assemblies in the context of COVID-19. This is one from Berlin last summer, where the demonstration against the government measures was dispersed for not complying with the distancing requirement. And we have seen also that sometimes governments abuse the anti-COVID measures. For example, in Russia, there's currently a blanket ban, a total ban on protesting, which was used in the last 2 weeks to arrest people who wanted to support opposition politician Navalny. And this in Switzerland, also last year, that's one of the early, again, communicated cases about COVID-19 to the European Court, called Communauté Genevoise d'Action Syndicale, which is a Swiss labor union which wanted to protest around the 1st of May, and which was prohibited by a general ban on protests in Switzerland for health reasons at the time. And they said their freedom of assembly was violated. And indeed, as I said, many assemblies have become impossible in practice in most countries. The UN Rapporteur on Freedom of Assembly has even said that although, of course, public health can be a reason to restrict assemblies, the crisis should not be used as a pretext to suppress rights in general. So there is apparently a danger that some governments would abuse the corona pandemic to more generally suppress any dissent in the streets. So turning quickly in the last 3 minutes to the European Convention on this, we don't have specific COVID judgments yet on assembly rights, but of course we do know that the assembly should be peaceful. That is the type of assembly that is protected, whether inside houses or on squares or online. So if assemblies do turn violent, even actively incite to violence, the authorities can react. And also restrictions on how many people can participate in assemblies or even where an assembly protest could take place are already allowed. We know from earlier case law this is allowed for the legitimate aims of public safety and public order and even protection of health. So we could, that is also the pandemic and the current pandemic, to see that this is an allowed legitimate aim to restrict assemblies. And finally, also general bans, so complete bans of demonstrations for a short time can even be justified under the European Convention. But there is a number of requirements there, which we know from a case against Russia, Lashmanking and others from 3 years ago. This can only be done, so this quite general ban on all demonstrations, which many of our countries currently have in a pandemic, is only done if there's a real danger of disorder, which cannot be prevented by less stringent means. This is really in a public order context. When the disadvantage of the ban is not itself outweighed by security considerations invoked to justify it, so the advantages should be bigger than the disadvantages. And finally, you cannot do it otherwise as a state. So it's not possible to do it with less restrictive measures. And generally, the court would say it has to be quite narrow in terms of time, so only for a number of weeks, and then again reassess whether it's still necessary to generally ban assemblies. So be quite careful, basically, is the message to authorities, to states. So this was developed in the context of public order, but could be applied to the context of public health. And finally, it's important also because there are a lot of tensions around COVID policies that authorities should not just protect one type of protesters, maybe those who are against government measures, but also those who are in favor and who also protected several groups against each other, which is also standing case law. So it should not be too dangerous to protest just because you're not protected against counter demonstrations. And I will end here with a very creative example. If almost nothing is possible for healthcare reasons or because it's legally prohibited, such as in Russia, where you cannot currently demonstrate in the streets, then people have creatively come up with one-person protests. Here, Ilya Azar was the first one, a human rights activist. He was arrested after his one-person protest, and then many others, friends and colleagues, started to print huge carton boards of his photo with a protest board and put that everywhere in Russia, so that there were even zero-person protests, just carton board protests. And it's reported that even one of those carton board figures was arrested, although it's not even a human. And with that, I will end with this very short overview of two important rights, freedom of assembly and freedom of expression in times of pandemic. Thank you very much for your attention.